Coming up on this program, we show you how to get connected. Find out how to choose an internet service provider. Discover the newest form of communication, electronic mail.
Ways down and ready to ride. One by one, billion by billion, been holding up half the sky. Raise your hand if you're ready and willing, if you know it's time. Time for a girl on time. Time for a girl on time. Time for
Hello, Erica. I'm sorry you've had a shite couple of days. Hello, everybody. Vicky, you're pink today. Oh my goodness. The day is turning around. Vicky wearing the pink crown. Might you be pink too? Come down to the chat and find out. Nice to see everybody. We have to get right into it today. We do indeed, because it's a long one and I would love it if we could get through it together. Can we get through it together? Oh, Lord. Can we? Oh, that's right. It wasn't today. It was yesterday. Calm down. I was just really quite mad at myself. Fuck. Might this one not work? Fuck. Let me double check something. Shall we? That's the wrong screen. Okay, give me a second. I did it wrong. Maybe there is something the matter with me, she says. We might have a change of plans. How's everybody doing, by the way? How's everybody doing? Tell me that. I figured it out.
Versus Jared Cash.
Hold on, Judge. Hold on. I figured it out. We're gonna be fine. We'll watch it like this. Ha. Oh, Erica, thank you so much. Thank you. Oh my God, go away. There we go. Hi, Courtney. You guys, I think that this hearing is about us in a way, in some cases. So, Vicky, keep us updated, but let's see what we have got here. Now that I can not have my heart attack, we have the video.
File number 267425. Time and date set for motion hearing. Chief Assistant Prosecuting Attorney David Walls appears on behalf of the people. Ms. Jessica Risky appears on behalf of the defendant, who is in the courtroom. We have a number of motions scheduled today. I believe the first in time may be the motion to strike. How do you wish to proceed, Mr. Walls and Ms. Risky?
And this is, in terms of the motion to strike, as the court may have seen, there's also the motion to disqualify. They're sort of the coins of this.
Yeah.
So we can we can proceed on that. Obviously, just wanted to make sure that those are tied together very closely.
Indeed. All right, let's go. I'm just trying to figure out which one was filed first.
His motions were filed first, Your Honor. Well,
Okay.
yeah.
Let's combine those, the motion to strike and the motion to disqualify.
Yes, Your Honor.
Well, you may proceed.
Thank you.
Yeah, that's the court. The court side is muffled.
As I indicated, Your Honor, the motion to strike, and then we have the motion to disqualify. Essentially, the opposite sides of the coin, same coin here. And it's our contention, as the court, I'm sure, saw the pleadings and the motion and the brief, and also the responsive brief to the counsel's motion. Says that it's down to a simple question. There's a fact that the prosecutor speaks with a witness prior to the hearing, become then a witness to that proceeding. We would say that Michigan law clearly says no to that question. In terms of the motion to disqualify, the defense is asking this court to take that extraordinary step of removing an elected prosecutor from criminal prosecution and appointing a special prosecutor merely because of an interview that was held a week before the hearing. Michigan courts have repeatedly held that disqualification is an extraordinary step that is reserved only when there's an actual conflict with the duties of the office. It's not a remedy for speculation or a disagreement or a tactical advantage. And I cited the cases of People versus Tenson and People versus Petri, Petri, to support that. In this case, the defense cannot show that there is an actual conflict. There's no personal interest. There's no financial interest. There's no prior representation, no divided loyalty. Simply someone who met with the victim in this case. Something that happens every day in the courts of Michigan. Something that happens in every criminal case, and I suspect every case in the country, where prosecutors sit down and meet with their witnesses. Tenson, the case I cited there, specifically recognizes that prosecutors may properly interview witnesses and victims when a prosecution is begun. That's not misconduct. That's the prosecutor doing his or her job. In fact, as the court has seen, and we've used at times during jury trials, the Michigan criminal jury instructions even go further, especially tell a jury, there is nothing wrong with a lawyer talking to a witness to find out what the witness knows or what the witness's testimony will be. The defense here is saying that simply that because Mr. Rakowski met with the victim beforehand, he somehow becomes a necessary witness. Again, Petri rejects that argument, Your Honor. The Court of Appeals held that a prosecutor is not a necessary witness where the information can be obtained from another witness and where the prosecutor does not possess unique material testimony. And that's exactly the case here. Every statement the defense claims to be innocent comes from the victim herself in this case, Your Honor. The defense counsel was able then at that time to cross-examine the victim. They will be able to do so again at the time of trial. If the defense believes there's inconsistency, she can then raise that with the victim. If the defense counsel believes the victim disclosed something that already did, she can then question the victim and or the detective who did interview the victim shortly thereafter after the preliminary exam. The source of the information is to come back all to the person who has that information, the unique source. Mr. Rakowski has no first-hand knowledge of the assault, the alleged KCC, the strangulation, the underlying facts of dispute. His knowledge is completely derivative from that conversation with that witness. So there's no basis whatsoever to disqualify the office. And in fact, if we were to go this far to say, well, then we have to disqualify the office and have it as a witness, that in essence, Your Honor, is now putting this office out of business. It now becomes then every case where we are indeed preparing for a case, preparing for a hearing, preparing for trial, this office is now then disqualified from even doing this job. And the flip side is just concerning as well. If a defense attorney interviews their witnesses in preparation for a hearing, in preparation for a trial, okay, let's call the defense attorney then as a witness to disqualify them and no longer let them be on the case. Either side could be then manufacturing that reason simply by that intent to, or announcing that intent to call the opposing witness. And that's just not the system that we have in this state. That's why the court requires showing that the testimony material, necessary, and unavailable elsewhere. And that's not here. Defense also said, well, we never got any notes from the prosecutor about this. That there's a violation of discovery. No, Your Honor, discovery was provided. All the information that the police reports had was provided. All the videos were provided. The pictures were provided. Prosecutors' notes, even assuming there were some in this case, and as I indicated in the brief, there are no notes, but even assuming they're prosecutors' notes, that's not discovery, that's work product. The fact that the victim met with the prosecutor just before and we then had, as the court may have seen in the preliminary exam transcript, the district court judge ordered that the people have the victim interviewed by the law enforcement. That was done, and that report was provided to council. She has now a statement from Detective Ford, who interviewed the victim about what happened as part of on that specific issue.
Happily stuck, Dwight. Happily stuck. Happily stuck with you. Thank you for 13 months. That was out of tune. Seriously, Dwight, thank you as always. We are happily stuck together, my friends, to watch things like this. And like I said, this hearing is going to come a little bit full circle for us, break the fourth wall a little bit. Ugh. That is the problem, Adam. My banana bread is delicious. These bananas were so ripe that it is delicious. I determined that has been the big factor. Lately, I've been utilizing my bananas too early. I needed to buy twice as many bananas and let them go browner before utilizing them for banana bread.
The defense had a preliminary exam. It's not a discovery device, it's a decision on whether or not there is sufficient evidence. In this case, in that case, in every case, probable cause to believe that a crime was committed and that the defendant committed it. There's not, I don't know if I can say every time, but there's many times when other testimony comes out that was not discussed, planned for, evaluated, whatever. Witnesses do provide additional details during their testimony. This does not invalidate the proceeding and does not create prosecutorial misconduct. And it certainly does not justify removal of this office from this case. The defense is seeking the most drastic remedy here, Your Honor, available: disqualification of this office, an appointment of a special prosecutor, or they also said dismissal of the CFC allegation, without identifying any actual conflict, any actual misconduct, or any actual prejudice. Please submit, Your Honor, that the fact that the prosecutor has interviewed the witness in this case, spoke to her, and then she testifies to the sexual assault, testifies.
Oh, hold on. I noticed this in the preliminary examination as well. Mr. Butterfield, you are not to speak. You have an attorney representing you. I'm warning you. Just providing a warning. You may continue.
Thank you, Your Honor. The witness testified regarding the sexual assault, Your Honor. That came out during the preliminary exam. The witness testified that she did speak to Mr. Rakowski about it beforehand. That indicates he had no unique knowledge about that at all, except she told him about that. Because of that, Your Honor, he's not a necessary witness. And to list him as a witness in this case, to list him to testify about speculation, to list him to testify about information that would be hearsay, we would say is not proper. And therefore, the request for the office to be disqualified should be denied. And we would submit that our motion to strike him as a witness should be granted, and that we should be able to proceed then forward on this case. Finally, there was no discovery violation. Counsel and defense was provided with all the information that we have and required by the court rules and by statute and by law. And in fact, prosecutor notes and conversations with witnesses, there's no requirement that we disclose that, except, and there's always that one big exception, as we all acknowledge, a Brady material. That's different. We're not talking about that here, Your Honor. We're talking about a conversation with the victim, preparation of the case. We ask the court grant the people's motion to strike and deny the defendant's motion to disqualify the office. Does the court have any questions?
I don't.
Thank you.
Ms. Risky.
Thank you.
You're welcome.
I'll try to keep this brief, but I want to be very, very clear that this is not a simple, we're trying to disqualify an entire office or add a prosecutor to our witness list because the prosecutor simply spoke to a witness. Attorneys are going to speak to witnesses. Absolutely. That's typically what happens. The problem here is that We are in the middle. Mr. Barfield is charged. He is appointed an attorney. Discovery, some is provided. In fact, the day before the preliminary examination, the prosecuting attorney's office reached out to me and said, hey, just a heads up, we're gonna amend the complaint. Cool, thank you for the heads up. Similar allegations, quite frankly, they could have done that as a preliminary examination, so I appreciated that heads up. Then when we get here the following day for the preliminary examination, it's a surprise, we have some new CSC allegations that the complainant admits to discussing with Mr. Rakowski a week prior. And that itself is a question because Mr. Wallace has handled everything for us as far as why is Mr. Rakowski doing that, okay. But the problem comes from, the rules for professional conduct. You cannot be an advocate and a witness. The problem comes is that we have an individual who now at this point in time has spoken to the police a number of times, admitting on the stand she spoke to Mr. Rakowski about it. They have intentionally withheld these new allegations that come up, surprise, at the preliminary examination. I have no idea, nor will I ever know, without having Mr. Rakowski as a witness, without calling him to the stand, what Mr. Irvine actually stated to Mr. Rakowski. My client will be
Visit
denied
away,
the
Donald.
opportunity
Thank
to
you so
impeach her
much.
because she's given a number of inconsistent statements all over the place. Yes, we were provided a police report that only occurred because Judge Ferris ordered that, hey, like, this needs to be documented and provided to the defense. So this happened weeks after the preliminary examination. So just because you got it to me late, it still denied Mr. Butterfield the right to have that information and to be able to fully cross-examine. I was able to briefly cross-examine a witness in regards to surprise allegations that the people knew were coming, they knew they were going to elicit, and intentionally withheld from the defense. Maybe they didn't, but the problem here is that it was. And without being able to question Mr. Rakowski on what exactly was said, my client is going to be denied those rights. That's why we have filed that. I mean, I understand, heck, he just
Damn right, that's the fun fund from Donald. Ahoy, ahoy, ahoy. Thank you so much, Donald. And thank you again for 21 months of support. Appreciate it. I love that. We're going to have a fun summer, you guys. We're going to have a fun summer. We really are. These are attorneys arguing. We don't often hear them arguing like this, but they are going at it. And I'm not supposed to stop it because it's so long and we want to get through it all tonight. That's what she said.
Prepped her in regards to, I'm going to be asking questions about the charges that Mr. Butterfield had already been formally charged with on paper. That would be one thing. He is the first sole recipient of new information that was withheld from us. By doing so, this is a unique situation in and of itself because we have, the police department is extremely close. Detective Ford is very close. He's the one who interviewed the individual a number of times. That wasn't, hey, there's some new stuff, Detective Ford, get down here. I don't know whether that happened because I'm never gonna be allowed to ask Mr. Rakowski those questions. And so I understand that this is a very unique situation that's being brought before the court, but it is a huge concern for me, for my client. And we believe that, his constitutional rights are being denied and we are not going to be able to impeach the victim based off of what she may or may not have said, because each and every single time she's interviewed by the police and she testifies, she has a different story. That's concerning. And, there is the argument of attorney work product and things of that nature, but here, I'm never going to be able to get.
I can feel my computer lagging. And then Christopher sends a gift. Oh my God. Christopher, thank you so much. Welcome, Linda. Oh my God, Linda's in the chat. She got a membership. Christopher is making dreams come true today. We love you. Thank you.
Get the information that I need without calling Mr. Rakowski as a witness. And so that is why we're asking for the special prosecutor so that I can call Mr. Rakowski. This is even more of an issue because it only deals with the allegation of the criminal sexual conduct, okay? So At first, we didn't think this was going to be an issue because Judge Ferris had declined to bind over on that account. So then therefore, it doesn't matter what she had said in regards to that allegation, we wouldn't be moving forward with that. So we didn't think we were going to have to worry about that, to worry about disqualifying the office. Well, now the people are trying to bring that back. So therefore, it's going to be the same issue. So, Your Honor, we would ask, I guess, I think the entire theme of today will be very unique. I'd ask that you reserve whatever opinion in regards to striking, disqualifying until after we have the determination on whether or not the additional charges for CIC are going to again run or not.
Again. Thank you, Christopher, again. Oh my gosh, look at this. New members. Thank you, Christopher. Are you on your week off, your staycation yet? If you are, I hope you're enjoying it. If it's coming up, I'm excited for you. We all have to make our own good vibes, and staycations are a great way to do it. Thank you, Chris.
Because they don't believe it's necessary. I just want to be there.
Whoa, how did I fucking speed it up so fast? I can't do that shit when I want to, and now it says normal, but did you not hear how fast that was?
Rebuttal argument.
Just in my head.
But you just had the evidence, we had, and she was able to cross-examine the victim in this case, as Mary Sam on those allegations. I was able to use that time to take it and find out more about it. Says she can't impeach because of doesn't have information. She's already indicated she already has impeachment evidence. She says that the victim gives different statements every time. So she has impeachment. We have not seen where this is unique. We've not seen where this is material. And then she says, well, the problem is he can't be an advocate as a witness. He shouldn't be a witness. Again, interviewing somebody ahead of time, preparing for a case, is not being an advocate. That's doing the job. Or he's not being a witness. That's doing the job of the prosecutor, an advocate. So we would submit that there is a proper basis to strike Mr. Rukowski as a witness and deny the motion to disqualify.
All right. Let's hear the other arguments. Now let's go to the 404B motion.
Very good, Your Honor.
I need to clear some room on my computer, and I can't bring myself to delete anything.
Reading the testimony from Alicia Cummings, pursuant to his court indicated 404B. And as background for the court, and I know the court, because we had a motion regarding the charge, has had the opportunity to read the preliminary exam and the essential allegations here of the assaultive nature of this case. And we've also submitted a notice pursuant to statute of bringing in a prior assaultive case. It's a crime.
Adult support provided by Christopher. Thank you so much, Christopher. I'm going to use some of that adult support to probably have to buy another hard drive to keep all this court. I'm a hoarder. I'm a court hoarder. And every time I see a judge's name that we don't see anymore, my brain's like, don't delete that. What are you, stupid? Don't delete that. And then Christopher sends along adult support and snaps me back out of it. Thank you, Christopher.
And so we provide that. So that case. There is now the current charge. And then Alicia Cummings is alleged that there's been things that happened even beyond that. It'd be outside the 10-year limitation on the initial statute that we just referenced. And I'm blanking on the citation site right now. I want to say 76827C, I think, or B.
I have a lot of external hard drives.
So that in this case, what we're alleging is, Your Honor, or asking this court to allow for is the evidence of Ms. Cummings from between approximately 2012 and 2014. The evidence is not being offered in this case for propensity or bad character. It's being offered for the non-character purposes that are recognized in the court rule, specifically intent, absence of mistake or accident, and a common scheme, plan, or system in what the defendant does. And when you look at all three of these cases, you know, it's clear that this is part of that same sequence of events and plan. This is relevant and substantial because one of the likely issues at trial will be whether the defendant intentionally impeded the victim's breathing, or whether the defense attempts to characterize the conduct as accidental, misunderstood, incidental. The repeated nature of these prior acts reflects any claim of an accident or mistake. The evidence demonstrates that pattern that intimidate, harden violence, escalating into strangulation as a means of dominance and control. The conduct is not isolated. It reflects a continuing and identifiable system spanning multiple victims over more than a decade. Now, it's also important to recognize, Your Honor, that because these allegations that Ms. Cummings has stated are back 2012 to 2014, so granted they are more than 10 years old. That does not defeat that, or does not say that, therefore, it can't come in. In fact, the case I cited, People versus Knapp, there was a CSC case, and the allegations there were 20 years old. And the court there upheld, said, that's fine, they're admissible, as long as it meets the other requirements, as long as it's logically relevant and sufficiently similar. Here, the continuity of the conduct, that actually strengthens that probative value around it. And while the evidence may be damaging, obviously, we would submit all evidence is damaging. That's not the question. It's not unfairly prejudicial within the meaning of 404B or within 403. It relates to the central issue here that's being disputed in this case. Did the crime occur? Was there a strangulation? And any potential prejudice can be adequately addressed by this court through a limiting instruction. I noticed also the defense's argument there in their response.
Love you, Christopher.
A response to the motion. Let me get that one straight. That she talked about how, well, she was strangled 500 times. No, that's not what she said. What she said was that Jared hit her, beat her, and choked her around 500 times. She said she was choked a lot. So there was
500 times to be choked would be terrible. Good night, Christopher. We love you. Thank you again. MB is lurking and listening, and we love it. Meow.
Assault of nature, yes, is what is part of this. But the strangulation happened a lot, and not this whole number of things of 500 times. Either way, it's that pattern of happening then, happened in 2020, and happening again now. That's why it's relevant and admissible under 440. Does the court have any questions?
I do.
Thank you.
Thank you, Christopher. You're so sweet.
Again, Your Honor, it's extremely troublesome because, you know, when we're looking at this, I mean, they're trying to introduce allegations, you know, they're 12, 14 years of age, completely unreported at the time that these allegedly occurred. There's no specifics. They're uninvestigated, uncharged, unsupported by any type of contemporaneous documentation. And it's ironic that these allegations are only raised after my client has become publicly associated in a highly publicized investigation in Huron County, where he's plastered all over Facebook, constantly all over TikTok and various parts of social media. I think that combination makes this type of evidence extremely dangerous. This is absolutely way more prejudicial than proven. I mean, what we're gonna have to do is conduct a mini trial within a trial to handle allegations of 12 to 14 years ago, that again, were uncharged, undocumented, never reported until 2026. I think that the timing makes it worse. I think that it's, I think that it's a problem. I don't believe that, it is in any way probative. I think it's absolutely prejudicial, and it offers little more than, we just want to invite the jury to conclude that, hey, he's a bad guy. So I want you to judge that. I want you to judge him on that. And that's not what these type of things are for here. It's, with the amount of time that has passed, I think it's going to be inherently difficult for us to be able to defend the outlandish claims. I mean, again, this is an individual that Mr. Barker met when he was 18. He was later incarcerated by the age of 19. They didn't even spend 500 days together. They didn't even know each other for 500 days at that point. So, it's not even true. But again, it's an unfair burden on the people, or on the defense caused by the people, because they want to bring up these old allegations that are way more prejudicial than probative, and I don't believe that it meets the test. We would ask that you not allow those in any way, shape, or form, because it's inappropriate, and it's any very, very minimal probative value that this, I don't even want to call it evidence, is poorly, I received a paragraph of this, or maybe two. I think it's substantially whatever type of probative value there is substantially outweighed by the danger of the absolute unfair prejudice, confusion. I think it's going to be misleading to the jury amongst other things. So we would ask that you exclude it, because I believe once you look at, MRE 403, 404B, that it should absolutely be excluded. Thank you.
Rebuttal.
The counsel said, well, mini trial within a trial. The trial is whether or not he committed the crimes that have been alleged against the current victim in this case. But the people are allowed to show that pattern, to show the sequence of events, to show the lack of a mistake or accident, the intent here. And that is the elements that are required to be proven in this case, as in most criminal cases. And so when we have that evidence, the rule is, we would submit a rule of inclusion, not exclusion, based on entity. And so we would submit that the basis is there, Your Honor. The evidence is there to show that pattern, to show that absence of mistake over the time period, and that is then a proper purpose for 404B, we ask the court to grant it.
The court's going to make a ruling on this one, because at least the first set of motions kind of tie in with the motion for preliminary examination. But here you're looking at MRA 404B, you have to consider MRA 403. The seminal case is People versus Vandervliet. Vandervliet is the seminal case relative to whether or not prior alleged bad act evidence is admitted. And 4 prongs have to be established. 1, evidence is offered for some purpose other than merely character or propensity to commit the crime. In other words, well, she did it before, so she must have done it again. So that would fail that prong if it's merely propensity or merely that type of character. The second prong that has to be established is that the evidence is relevant to a fact and consequence for purposes of the trial. Third, the weighing of MRA 403. That is that the probative value of the evidence is not substantially outweighed by the danger of unfair prejudice. And then finally, the 4th prong essentially is a limiting instruction, which the court has available to it under the model court rules. Here, the allegation is assault by strangulation. It's alleged that between 2012 and 2014, a similar circumstance occurred. It's further alleged that a similar circumstance occurred in 2020. As a result, the people's position is simply that, well, wait a second, this is not just happenstance, something is going on here, and it's not for character or for propensity, but it's because of a plan or scheme, common scheme or plan, I should say, or intent or absence of mistake. The defense position is, first, it's potentially a trial within a trial. The court doesn't deny that, because certainly you're trying other alleged crimes that occurred many years ago. And we're talking back in 2012. And through 2014. That's a long time ago when you look at the current age today in 2026. So I appreciate the defense's position here by stating, look, this is old stuff. He was 18 at the time. How can that tie in? How can that relevant, I should say relevant, how can that be admissible under 404B with the time that has elapsed? Mr. Wallace's position is very simply the case he cited, People versus, stand by, Knapp, cited the 244 Mishap 361. The court examined a 20-year-old sexual misconduct act for 404B and held that the appellate court held that the evidence was highly probative to the defendant's common scheme. That was 20 years ago. So at first blush, though, you look at it and say, well, geez, that's a long time ago. Now it's being alleged that it's 2012 through 2014, alleged in 2020, and now obviously the charge is here today. And so when you look at the first prong, is the evidence offered for some purpose other than under a character to conduct theory or a propensity theory? And the court finds that it is offered for a common scheme or plan. That when faced with similar circumstances in the past, not on one occasion, allegedly, but allegedly on 2 occasions, that this occurred. So the court finds, at least as to prong 1, that there is at least a showing of common scheme or plan in how to handle the situation, as may allegedly happen back in those years.
Good night, Christopher. I'm making
prong.
butter as we listen to this. Thank you so much for the adult support. You saw this was liquid when it first went in, then it's not coming out. It's currently just at whipped cream stage and about to turn into butter and buttermilk. But seriously, this is very, 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 very serious, as MB puts. You absolutely need consent, folks. I got consent from this bottle. We talked about it earlier. It's written. Don't worry about it. Don't worry about it. I got consent. This guy, Mr. Butterfield over here, wrong kind of butter. No consent, allegedly. Anyways, you're going to hear something coming up, by the way. The judge is not happy that we're watching this.
The evidence is relevant to a fact of consequence of the trial. Well, there's no question of that, because it's alleged that there was this strangulation in 25, I believe, whatever year it was, and back in 20, back in 2012 through 2014. So it is evidence relevant to a fact of consequence. The biggest issue is MRA 403, that the probative value is not substantially outweighed by the danger of unfair prejudice. Now, I'm going to be honest, in my defense days, I never liked this rule. This rule was never a rule that I particularly enjoyed at all, because as Ms. Risky stated, it is common to be a trial within a trial. And the idea here is, well, yeah, all evidence is prejudicial. There's no question, as cited by Mr. Wallace. But you have to look at, is it not substantially outweighed by the danger of unfair prejudice? And here, you have to look at, again, under MRA 403, the court may exclude relevant evidence if its probative value is substantially outweighed by a danger of one or more of the following: unfair prejudice, confusing the issues, misleading the jury, undue delay, wasting time, or needlessly presenting cumulative evidence. And at first blush, it would appear to the court that it wouldn't pass 403. But under Vandervliet and all the seminal cases after it, the appellate courts have...
It's happening, you guys. The buttermilk is going to separate from the butter, and it's going to make a slapping noise that will begin soon. Also, this bottle was specially procured for me by somebody who knows exactly what I really am. Okay, I gotta shake it more. Sometimes you think it's almost done, and then all of a sudden you're like, fuck, I'm gonna be here for another 5 fucking minutes.
Determined that this rule is a rule of inclusion rather than exclusion. And again, back in my defense days, I was never a fan of that. Never. Because you can just kind of throw anything out there willy-nilly, so to speak, and then the jury hears it, well, geez, he must have done it before, then he did it again. That's the danger. That's the huge.
Here we go. You hear that? That's because the butter has separated from the milk, which is the buttermilk now. You can hear it. Anyways, so great. I love it. This is not ideal to get the... Oh, I'm so tired. Except I'm not. I can handle it. But seriously, I don't know if I'll be able to get the butter out very easily from this container because of the top, but you can hear that buttermilk separate, baby. The spray. Oh, the spray. Success.
Huge danger. But when you analyze it under the seminal cases, this court finds that the probative value of the evidence is not substantially outweighed by the danger of unfair prejudice. It's prejudicial. There's no question about that. Court does not deny that. But it doesn't rise to the level of unfair prejudice based upon all the previous cases, and also considering the matter of People versus Knapp, where the time frame was 20 years ago. Here we're talking approximately 12 years ago. So and this court is bound by all the appellate decisions. The court just can't make a willy-nilly decision based upon how the court feels. It's based upon what the upper courts are telling the lower courts the law is. And that's the law. Finally, a limiting instruction, that would be the fourth prong, would be provided. As a result, this court finds that the evidence is admissible under MRE 404B, and Mr. Wallace will present an order to that effect.
Yes, Your Honor. I will also file a amended witness list, adding her as a witness.
Very well. Next issue.
Motion limited, Your Honor.
Go ahead.
Need salt.
A little bit of background on this case, on this matter, Your Honor. A couple of things. First off, and I know the court's read the exam, there were questions raised regarding criminal history of the witness, the victim in this matter. And for the court's information, I provided a letter to counsel back on the beginning of April. There was a prior conviction of being a coin box here in Huron County. And that was under, actually not a conviction, it was a Homeless People Training Act, is what successfully completed. In 2025, there was a charge and conviction of mail theft out of St. Clair County. That was a misdemeanor. At the time of the hearing, the witness was currently on probation. I don't know if that's true as of today. I know that she could very well be still on probation. I'm not saying otherwise. I don't know if it's true as of today for that misdemeanor. Then also, for counsel, I let her know this, but in the letter I indicated that the witness had been charged with retail fraud, third degree, a misdemeanor. That was charged in November of 2025. At that time, when I sent the letter, it was still pending. And I let counsel know that on April 16th of 2026, the witness pled to the charge of retail fraud, third degree, and was sentenced at that time to fines and costs. So at the most, there's these three misdemeanors as far as background that, and of course, one of them is not even conviction because of Homeless People Training Act. We would submit to Your Honor on those particular aspects. Those are not admissible under the court rule under 609. They're not felonies, and therefore that's the first prong. There. That's punishable by assessment of 1 year. Now, I think counsel's response said that she acknowledged that to be the case, and so I'm not going to push that, but I want to make it clear for the record that we would submit that prior convictions are not admissible as impeachment for impeachment purposes at all. council vote and says the next step, that although those may not be irrelevant or admissible, the fact that she had a warrant outstanding, was on probation, that's fair game. And again, we were switching around, same thing applies here, that's still under 609. The warrant has no bearing on truthfulness or honesty or whatever, any situation in that regard whatsoever. I would also note that since that time, she has been arrested on that warrant, and that there's no longer a warrant outstanding. That has been resolved. So now we're going to try to go back to old times here and say, well, back then, we had this going on. And that wasn't even in effect at the time of the alleged incident here, Your Honor. That happened afterwards. So it has no pending relevance in this case. It has no admissibility based on the court rules. Finally, there is the issue regarding drug use of the witness. And I would note, Your Honor, that first off, we are not saying the council cannot ask questions regarding the drug use around the time of the incident. That's entirely appropriate for showing whether or not reference of memory and so forth. But then we had, well, isn't it true that a month earlier you were using this, and the time they're using it? And that was what a couple of questions that came up during the exam. Those are not relevant, Your Honor, and have no bearing, and no purposes should come in. They're just meaning to strike or attack the witness in terms of credibility of drug use, not of honesty, not of truthfulness. Counsel in her response said, well, it could go to show her memory issues. Well, that kind of argument, Your Honor, can be used in most any type of drug. Alcohol is a drug. So you were using alcohol back 2 months ago, right? And that can affect your memory now. That's not what the law is, Your Honor. The law is at the time of the incident, the time of the charges are brought, it could be relevant and admissible, and we have no problem with that. But beyond that, that's where we're saying the motion limit should be granted to limit it for that purposes only. It could shift the burden, and probably shift the jury's focus away from the defendant's conduct towards collateral attacks on the victim's character. And that's what the rules of evidence are designed to prevent, Your Honor. And that's why I would submit that a motion, or at least a ruling by this court, to not allow that to happen in front of the jury is appropriate in this case, where they're not allowed to raise issues regarding the prior convictions. The warrant that was outstanding at the time is no longer outstanding, probation, and or including that drug use beyond the scope of time of the incident. Does the court have any questions?
Do not.
First and foremost, as we would agree that the misdemeanor conviction would be used for impeachment, I had detailed that in my response. Continuing though, the issue comes from, again, Mr. Ryan's continually changing statements, and the fact that she was on probation at the time. She testified in the preliminary examination about, going to this drug test, going to that drug test. She admitted to drug use at the time of the offense. She was absolutely trying to avoid jail. It's our contention that the reason she went to the hospital in the first place to get checked out, where she refused to cooperate with anyone, gave a bunch of different stories again. Was so she could get out and have this test the next day because she was going to test dirty. I think all of those things are relevant. It goes to credibility, it goes to motive. We think that that's important. I'm sure it's the same thing. We can give a limiting instruction to the jury. Those things are important to be able to have the ability to cross-examine for Mr. Butterfield. The same thing in regards to the drug use. Obviously, it's not. I'm not going to ask if we're using methamphetamine in June. That's not relevant. But I believe that the questions about her drug use during the time frame that she's alleging to have been hanging around with, having whatever type of relationship with the defendant would be relevant. So we would ask that type of question be allowed. Again, we would agree that the misdemeanors would not be able to be used for impeachment, but there is going to be, I believe, testimony from various witnesses in regards to obviously the ever-changing story, and I believe that it is relevant because, again, it goes to the motive for fabricating a lot of things that she has around her. So we would ask that the the probationary term. I mean, I don't know how the court is going to get around. I was going to drug test. I mean, this stuff is already within the preliminary examination. I mean, that's fair game for me to question her about again, Your Honor. So, I think a limiting instruction to the jury would be able to correct any type of attack on Ms. Erline's character.
What was she on probation for, Ms. Richmond?
Mail theft.
Mail. Okay.
So, and we would obviously keep that out,
Okay.
because it can't be used.
Well, we won't mention the crime, but we'll mention probation. How is that not the same thing? Talking about. It's still dealing with criminal offense, misdemeanor offense. It has nothing to do with the case before the court this time. Counsel says, well, it came up in prelim exam, so we can start getting now. No, that's why we're asking for this motion now, so it doesn't come up at this point in time in trial. Because again, that's what the court will say. It's not admissible. Counsel argued as far as that, well, we're not asking about drug use in June or that, but just on the time she's with him. Again, that has no bearing on as far as the incident itself. And we would submit, no question again, during the incident, yes. That's fair game. She has all the questions she wants. But it's beyond that, but it has no bearing and no relevance on her memory at that point in time, on her testimony at that point in time, on what she was saying at that point in time. And, or what she's saying on the stand for this court and the jury, if we go to that point. So we would submit that the motion would be as a proper situation here where the court should rule that as counsel has acknowledged, prior convictions don't come in as to the 3 misdemeanors. We would argue though that the probation does not come in, the warrant does not come in, and the drug use beyond the time frame of the charge that's been brought does not come in. Thank you.
This is the people's motion in limine to preclude evidence or argument regarding the alleged victim in this case, Ms. Erline. And in part, at least what the motion was from the start, alleged, well, not alleged, prior misdemeanor convictions of the alleged victim, pending criminal charge of retail fraud, third, probationary status or prior warrants, drug use outside the time frame, is what is being looked at by the people to exclude in a motion to eliminate. And the court is bound by MRE 609. MRE 609 deals with prior convictions. This does not involve MRE 608 regarding character for truthfulness or untruthfulness. It's regarding the alleged, I should say, alleged prior convictions of the alleged victim. And I think it's conceded by the defense of the victim's prior misdemeanor convictions would not be allowed in, and they are not allowed in because under MRE 609, well, first, if the crime involved an element of dishonesty or false statement, it's going to come in, as long as it's within the 10-year rule. But if it involves theft, then you have to look at, is it punishable by imprisonment for more than 1 year? And the court determines the evidence of significant probative value and character for truthfulness. So all of the priors, I'll say priors, involve theft of a coin box. Again, that is according to the people and Ms. Risky, that is a misdemeanor. The mail theft conviction, misdemeanor, and retail fraud, third, also a misdemeanor. The retail fraud at the time, as I understand, there was a warrant pending. Or there was a pending charge.
And just to put on the record, so it's clear, Your Honor, that case was currently pending at the time in district court.
Right.
The warrant was on the retail fraud.
Okay.
Sorry,
Probation
probation violation filed.
Probation violation. Got it. I'm clear.
I'm sorry.
No, don't be sorry. I'd rather be clear than not. And so clearly the misdemeanors are not allowed in under 609 because it fails prong or paragraph A. None of them, 2A, are punishable by imprisonment for more than 1 year. So they're out. The issue is, well, she was on probation for the mail theft at the time. The defense position is, well, if she's on probation, that could be a reason to fabricate because of the fact that, these things are pending, warrants, everything going on out there. But on probation status, you have to look back at what she's on probation for. That's a conviction for the mail theft. And MRA 609 precludes that. So clearly, the probationary status, the retail fraud, mail theft, the Heidi case as well, are inadmissible for purposes of trial. The rules of evidence are very clear. Now, regarding drug use outside the time frame of the alleged incident, clearly, any consumption of controlled substances, alcohol, anything that could warrant someone where their mind is affected in some way, shape, or form would be fair game, because of the fact that it affects your ability to perceive what's going on. It may affect memory, it may affect a lot of things. So clearly, that's fair game. If it's alleged, and I believe it was contained in the exam transcript, that I believe methamphetamine may have been used by the alleged victim at the time of the incident, absolutely fair game. That's admissible. But if you move back in time, a week prior, a month prior, etc., that's beyond the scope. It has to be at the time of the incident, because that describes the alleged victim, if she were to testify, or she would be describing what allegedly happened on the night in question, or day in question. Perception, memory, fair game, but anything prior to that is beyond the scope. So the motion relative to people's motion in limiting is granted regarding the convictions, any pending charges of retail fraud, which have been resolved, probationary status or even prior warrants, drug use outside the time frame of the alleged incident are all inadmissible.
MB, knowing the moment that I started to doubt myself, I looked at the clock. I thought, oh no, we got lots left. But thank you so much for the ongoing support that keeps me going. Thank you. Yes, that shake effort was a lot, but you know what? You got to keep up your practice. I may be a single lady, but I got to be up on my game. Let's put it that way.
Prosecutor prepare the appropriate order relative to that.
Yes, sir.
But it does appear, though, that according to Ms. Risky, there's abundance of other witnesses who may be testifying regarding prior inconsistent statements. That's a whole different ballgame. That's a whole different ballgame at this point. So at that point, if it passes the rules of evidence at the time of trial regarding prior inconsistent statements, it'll be for the jury to hear. They'll make their decision.
And Your Honor, I don't question that part. Counsel is always allowed to bring up inconsistent statements. I would ask, though, that they also be ordered not to discuss other drug use outside of that time frame of that incident.
I've made that ruling.
Well, for those witnesses as well, Your Honor, I'm just saying, I want to make sure that they don't try to bring it up through a defense witnesses as opposed to through the victim.
MB. You know what? I've been told I'm overzealous sometimes, and I'll take it. And Bill, it's not your fault, Fee. It's not your fault, but you missed something. You missed something big. But we are glad to see you here now. Thank you.
I see. Ms. Risky, your response?
I mean, then you're asking me to I can't guarantee that somebody's not gonna spit that out. I mean, I think that is extremely overly broad, and I mean, I don't know whether or not that's gonna be able to be controlled. Obviously, we'll attempt to elicit that in any way, shape, or form, and the court's already made the ruling, but, you know, I can't control each and every single one, so I mean, there's a concern about that, obviously, but it would be our intention to elicit that from other people, and the court's already made their ruling.
Years ago, we had a prosecution witness testify, Wallace, a detective sergeant.
Yes, Your Honor.
Who brought up testimony, and a chief of police in another case, I believe, that made statements. And it was spit out as well, and it was just like, ooh. And we had to call the jury out and address that. So I understand, clearly, we've had that experience before. It's, the alleged drug use is limited to the days in question. Period.
And I'll just ask for the council to instruct your witnesses that, so that if there are any witnesses at that point in time.
Correct. The court will do so.
Thank you.
All right, next motion.
I think that this is the last motion for the people. And sure. And the final motion, Your Honor, we're asking the court to amend, allow the people to amend the information. And in essence, to allow for an amendment to CSC first degree, Your Honor, or an alternative CSC third degree, but both are appropriate in the situation. What we're looking at, Your Honor, is that first off, we recognize that this court has to find essentially for the CSC third abuse of discretion, because the district court made a specific finding that it was not there. She found that it should not be bound over on that charge. So what the court has to look at is, this court has to look at in that regard, is when a district court abuses its discretion, when it misapplies the law, improperly weights the evidence, or reaches a result outside the range of principal outcomes. That's sort of the standard for the court to look at in terms of what is an abuse of discretion. And that's what occurred in this case. As the court knows, in district court, and how in a preliminary exam, the purpose is not to determine the guilt beyond reasonable doubt. The question is simply whether there was probable cause to believe that a felony occurred and the defendant committed it. The magistrate does not determine whether the prosecution has proven that case was tried. Here, the lower court acknowledged that intercourse occurred. The complainant testified that the defendant told her to remove her clothes. The victim said no. She further testified that she did not consent to sexual intercourse. But that's not where the record stops at, Your Honor. The victim also testified that the defendant repeatedly strangled her, that she could not breathe, she feared for her life, that she believed she might die, and that she believed this could be the last thing she would see. The district court found probable cause for the multiple assaultive felonies that are arising from that same incident, that same course of conduct, including the strangulation offenses. Under Michigan law, force or coercion, as or coercion, includes fear, threats, violence, and submission resulting from ongoing assaultive conduct. A reasonable inference of coercion plainly arises from that conduct that occurred and from that record, Your Honor. The district court's really improperly focused on those perceived gaps in the testimony, specifically what happened between the victim saying no and the intercourse itself. Under the probable cause standard, the lower court is required to consider the whole record, not just bits and pieces, and draw reasonable inferences, not demand a perfectly uninterrupted narrative. And that's particularly important here now because the assaultive conduct, the fear, the strangulation, and the sexual penetration were all part of one continuous course of conduct.
She never said that. She said no. I know that you're gonna yell at me, but I'm not gonna.
No, sir, this is, no, listen, I am not allowing that.
Not,
I saw what you did or heard what you did in the court, sir.
That's bullshit. That's bullshit.
Okay, remove him.
Remove me.
You are removed.
I'm not gonna sit here and listen to that.
You are not going to speak
He's allowed
to
to
the
just
court
say
in that
whatever he
fashion,
wants.
sir. You are removed.
I'm not
from this courtroom.
disrespecting you. He's not allowed to just make shit up. She never said she said no, and she said I didn't force her. He's allowed to just say whatever the fuck he wants. That's fucking bullshit. There ain't no way in hell I'm listening to him accuse me of some shit like that.
Sir, stop or I'm going to hold you in contempt.
What the fuck's that gonna do?
Stop. Stop right there,
Man,
Deputy.
contempt. I got nothing but time.
I'm
Apparently.
holding you in contempt, sir.
Yes, sir.
Direct contempt for not following the court order. I
Absolutely.
am trying to be as reasonable as possible, listening to the evidence. They have a position, your
He's allowed to
attorney
lie
has
to
a
you?
position. I find you in direct contempt. Is there anything you'd like to say?
Yes, I'd like to say I would like to see you sit here and listen to these things and not have something to say yourself, when I hope you listen to that testimony yourself before today, because her exact words were, I didn't force her, and she never said that. She said no one time on that record. So if you bind this over, this whole fucking county is corrupt. That's what I have to say.
10 days in jail,
Yes, sir.
consecutive.
Can I approach on it?
Wait.
That seemed to piss him off. That seemed to piss him off. There is more, certainly. I didn't quite hear that part. Another moment to remind you that I live in Canada, not America. Just so you know, anybody watching. No, we talked about it earlier. Please get consent for your strangulation. There is somebody out there that wants it, I promise you, but you've got to get that.
What the court is going to do is we are going to dial him in from the jail, mute his microphone, so he can be involved in the proceedings. I
Yes,
want
sir.
him to at least hear what's going on. I want to be fair to him as well, despite how he may have been acting in court. Sergeant, when the defendant returns back in, could you please place him in the Zoom room, dial into Zoom so that he can at least watch the proceedings? We're going to have the microphone muted. Thank you.
The Zoom room. Oh, and then they waited. And did they ever come back? They did come back. Eventually, here we go, let us see.
Back on the record, please. Court recalls matter People versus Jared Cash Butterfield. The court took a brief recess, went off the record, and prior to that, the court found the defendant in contempt, direct contempt for outbursts within the courtroom. He had been warned prior to. As a result, I found him in contempt. He was given 10 days in the county jail and removed from the rest of today's proceedings. The court made arrangements with the Huron County Sheriff's Office to have the defendant placed in a Zoom room so that he could watch the proceedings. And the court stated off the record, I want to provide fairness to the defendant so he knows exactly what's going on. I don't want to operate in a vacuum for the defendant. He needs to see and hear what's going on. He's entitled to that. And by at least having him in the Zoom room, he can at least observe it. And then certainly if there's an issue, we could let counsel know. Counsel could address the matter. I've been advised by the Sheriff's Office here just a moment ago that the defendant refuses to enter the Zoom room and refuses to take part in any proceedings relative to this proceeding today. Deputy, any further details regarding that?
Just that his attorney could let him know how the hearing went.
But can you state for the record what the information was that was provided to you?
That we were gonna put him in the Zoom room, and he said that he didn't want to go in the Zoom room. The attorney would take care of it for him, and that she would inform him what happened.
All right. Well, the court made every attempt to have him here, and there was no issue having him here in the courtroom until the outburst, which the court's not going to tolerate. I saw in the district court proceedings when I read over the transcript, there were numerous outbursts that this court is not going to tolerate, period. We can't. This is we have to have a proper proceeding, proper decorum, and as a result, the court did what it did. If he does not wish to proceed via Zoom, we're going to continue on. I don't know what else to do. So in light of that, Wallace, you may continue.
Your Honor, can I just say something from
Go
our
ahead, please.
And I understand and I have every reason to believe that the deputy is being truthful, but just I'm placing it on the record that I didn't have any time to confirm with my client whether that is or is not true. We will do whatever it is that you want to do, but for the purposes of just preserving the record and protection of myself, I just wanted to make that note.
You know, and to protect everyone involved, I think it'd be a wise idea for you to go see your client, speak with him. And when you're finished, you can report back to the court, we can revisit with them.
Okay.
So we'll go off the record.
Okay, and normally this is where we would end, but we're not going to end. Courtney, I would allow a next right now. I would, in fact, encourage it. This is a great time to get yourselves a drink, but we're going to get started again here. I promise you. We're hoping to finish her off. And I think this is the one that's going to have a message for us, if it plays.
Court recalls matter people of the state of Michigan versus Jared Cash Butterfield, 26-307-425. The court took a recess to allow counsel the opportunity to speak with her client. Ms. Risky, have you had that opportunity?
I have, Your Honor, and he did confirm that I can proceed with this hearing without him being present, so I just wanted to know that for the record.
All right, and I will say for the record as well, if the defendant can promise to control his comments and be respectful, he's welcome back in the courtroom. But if it continues, the court has to do something.
I don't believe that he wishes to be here, to be quite honest with you, Your Honor.
I understand. I understand. And that way we shall continue. Mr. Walsh, you may proceed.
Thank you, Your Honor. And you know, what I was talking about that time was how the victim in this case indicated that she did not agree with this, that it was without her consent. And in fact, I'm going to go straight to the examining hearing the transcript. Initially on page 21 of that hearing, she was asked a question. And this is before you left the house, this line 6 of page 21. Yes, answer yes, question. And he asked for you to take your clothes off. What was your response? I said, I don't want to. Question, why? Answer, I just got hurt, assaulted. I didn't feel comfortable taking my clothes off. Question, what happened then? I won't say forcibly happened, but he proceeded to tell me I should. Question, and did you? Answer, I did. She continues on having this sex intercourse. And then on the next page, page 22, lines 1 and 2, was this with your consent? No. Those are the elements, Your Honor, based on everything else that happened around the circumstances in this case of that incident, as far as the testimony that happened, that would demonstrate force or coercion. When you look at the assaultive natures of the crime that happened, when you look at her saying, no, I don't, this is wrong, that was not with her consent. Therefore, based on the entire thing, and again, the strangulation, it's all part and parcel of one continuous course of conduct. Now, Your Honor, we are asking that the court actually have charge of CSC first degree. And instead of the third. And in that regard, there, again, this is before the court, as far as the cases here before the court, it's been bound over. So this court now has the authority, the jurisdiction to decide that. And based on the exam transcript, the evidence independently establishes that probable cause, that the penetration that we're talking about, that it required obviously for CSC first occurred, and occurred during the commission of the other felonies, which the defense already been bound over. Under the People versus Waltonen, W-A-L-T-O-N-E-N, force or coercion is not even required in that situation, Your Honor. It's as long as there's a direct interplay or interrelationship between the felony conduct and penetration. In fact, her testimony specifically said that. Additionally, under McGee, once the jurisdiction has vested in the Superior Court the authority on buying over, the court has that authority then to allow for the information to be amended. I would suggest, Your Honor, there's no unfair surprise here. These are facts that were alluded during the preliminary exam. The defendant heard the testimony, his attorney was able to cross-examine the victim, and they've been on notice of the factual basis that we're talking about here from the charts, from the outset of that, from the exam of that hearing. Under McGee, the question is really, that the defendant had the notice and an opportunity to defend, and in this case, he does. There was the hearing that was held, they had the cross-examination, and now the trial is not set until the end of August, at this point in time, of August 25th, when there's a trial date. District Court's ruling, Your Honor, was internally inconsistent in this whole situation here. The court found that the victim credible enough to bind the defendant over on the violent strangulation felonies arising out of this vaccine incident. They said, well, I don't find probable cause so for forced coercion or for the CSC charge. That inconsistency demonstrates that abuse of discretion and a failure to draw reasonable inferences from the evidence, as is expected and required of a district court magistrate. And for those reasons, Your Honor, and the reasons that are in the brief and so forth, I'm not going to go through everything honestly, because courts I know had that opportunity to look at those. We're asking the court to either allow the information to have a CSC first degree charge involving the felonies, or the alternative, the CSC third degree, and find that the district court abused their discretion and not binding the defendant over on the charges. If there's quite any questions.
I do.
Thank you, Your Honor.
Cool.
First and foremost, we are in the position that Judge Ferris actually got it right. Ironically, knowing about the allegations for over a week prior, not advising the defense, they did seek the CSC first being that going their examination. I think it goes without saying that, you know, here we are again, prosecutor getting multiple bites at the apple. I think it absolutely is an unfair advantage, because if we had known about the allegations prior to the preliminary examination, we weren't just as surprised. Obviously, the different preparation, things such as that, being able to ask different questions, but I don't believe that there is any type of abuse of discretion here. You know, they're relying on, I mean, she was very specific, it was not forceful. And it was in regards to taking off her clothes. There is a giant gap in everything. And then, you know, Mr. Wallace follows up, was it with your consent? No. Without any other information, none. I mean, probable cause still has to be there. And when Judge Ferris gave her opinion, I mean, she was very clear that people have rested their case in chief, that's the allegation of criminal sexual conduct, third degree. The court's reviewed its notes, reviewed the exhibits, and re-listened to the testimony of the witnesses. They've also reviewed the elements of the offense. And the court does not find that the elements of criminal sexual conduct have been met. They stated they were by the door, ready to go. We asked her to take her clothes off. She said no, because she had to go get drug tested. And then the testimony skips to they were upstairs having sex. His mom shows up, the witness was in the bathroom putting on makeup, etc. She specifically testified she was not forced. She may have not wanted to have sex with him, but she can testify that she expressed that to him in any way. So there has to be some kind of verbal something, Your Honor. We don't believe that it's been met in any way, shape, or form. We believe that Judge Ferris got it right in denying the criminal sexual conduct bind over in the third degree, but we also don't believe that first degree is met either, because again, the testimony, there's gaps, there's nothing there. I mean, she has allegations from all over the place, things that, you know, she's alluding to have happened way before, because something may or may not have happened hours before, days before, that doesn't meet the requirement of the first degree criminal sexual conduct. We would ask that you deny the people's motion in regards to this, because there is no probable cause based off the testimony that's been provided. You have the transcript, I trust that you reviewed it, and I don't believe that there is any basis that that charge should continue. And we would just, again, ask you to review the record, review all of those things. We believe, again, Judge Ferris got it right. Thank you.
Your Honor. From the court, lower court said, and the specific testified she was not forced. What she said was, I won't say forcibly happened, but he's treated to tell me I should. After she's been strangled, different times, after she's been assaulted, different times. That's forced coercion, Your Honor, based on the incident that occurred at the time. She specifically said that it's not there. She specifically said, I told him I don't want to. That was expressed. So we would submit that, yes, the court made a finding on it, and it's our position, obviously, by the motion, the court was wrong, and abused its discretion. He should have been bound over as charged at the very least, or at the very least as charged in the CSC third, We were also asking them, the CSC first degree charge be implemented based on the facts and the law that provided. We're not asking for anything that the law doesn't offer. We ask the court to so move.
Thank you. This is the people's motion. In some respects, an appeal, actually, an appellate form was provided to the court as well, based upon the prosecution's feeling that there was an abuse of discretion in the final decision made by the examining magistrate here. And the court has to also consider MCR 6.112H. Under 6.112H, the court before, during, or even after the trial may permit the prosecutor to amend the information unless the proposed amendment would unfairly surprise or prejudice the defendant. So that's in play as well. What happened at the preliminary examination, as the court understands, and the court did review the transcript multiple times, as a matter of fact, the defendant was brought before the court on the charges contained within the information. I don't recall, and prosecution and defense can correct me if I'm wrong, I don't believe there was a statement made on the record prior to the exam starting that the people were seeking to add a CSC charge.
I think that's correct, Your Honor. I would agree with that statement.
No, it was not until the testimony was elicited, we were surprised, and then it was after the conclusion.
Okay, so I had the same memory of that, because I was looking at that, and normally that would be obviously further notice to the defense. Hey, look, this is what's going on, and as a result, the defense could maybe cater their questions toward that aspect of it as well. Where I think it came out after you review the transcript was the testimony of the alleged victim. And the alleged victim testified in part as follows regarding the alleged criminal sexual conduct. This is page 21, beginning around line 9, actually line 3. Actually, we'll go back to 20, line 25. Okay, now in terms of at the house, at his mother's house, did anything else happen there that you can recall regarding your clothes? Answer, this is page 21, line 3. After it was time to leave, I had to go to drug testing. For that, we left to go to my probation drug testing. He asked me if it was a bad time to take my clothes off, and I questioned, and this is before he left the house. Answer, yes. Question, and he asked for you to take your clothes off. What was your response? Answer, I said, I don't want to. Question, why? Answer, I just got hurt, assaulted. I didn't feel comfortable taking my clothes off. Question, what happened then? Answer, line 15, I won't say forcefully happened, but he proceeded to tell me I should. Question, and did you? Answer, I did. Question, what happened at that point? Answer, we had sex. Question, intercourse? Answer, intercourse, yes. And there was testimony regarding the type of intercourse. And then on page 22, line 1, was that with your consent? Answer, no. And that's part and parcel of where, and again, I'm not getting into the prosecutor's head, but that's where it appears that maybe the light bulb went on and said, hey, we may have an additional charge here to bring, which was brought up at the time of making the argument before the examining magistrate in this matter. The examining magistrate in this case had taken the matter under advisement, and a subsequent hearing was held, and the examining magistrate ruled in part and this is page 9 of the subsequent transcript, line 1. However, the people have rested their case in chief, and as to the allegations of criminal sexual conduct third degree, the court has reviewed its notes, reviewed the exhibits, and re-listened to the testimony of the witness. And the court has also reviewed the elements of this offense. and the court does not find that the elements of criminal sexual conduct third degree have been met. The testimony started that they were by the door, ready to go. He asked her to take her clothes off. She said no, because she had to go get drug tested. Then the testimony skips to they were upstairs having sex. His mom shows up. The witness is in bathroom putting on makeup. Then the witness went to go get drug screened. The testimony skipped the important part, which is how they got upstairs naked having sex. And the witness specifically testified that she was not forced. She may not have wanted to have sex with him, but she did not testify that she expressed that to him in any way. So the court does find that element 1 was met. There was sexual intercourse. However, the court does not find force, or coercion based on the witness's testimony. Therefore, criminal sexual conduct third degree is not bound over the circuit court. Defendant is discharged as to that count. So that was the examining magistrate's ruling. And if the prosecutor feels that, in their opinion, the examining magistrate erred in finding the defendant over for trial, they have the right to appeal to the circuit court. That is under People versus Robbins, 223 Mishat 355 to 1997 case. And a reviewing court, namely this court, may not reverse a judge's bind-over decision absent an abuse of discretion. That's cited in People versus Yost at 468 Mich 122. It's a 2003 case. There, an abuse of discretion. Well, let me back up. In that Yost decision, the fact that the district court judge may have reasonable doubt that the defendant committed the crime is not a sufficient basis for refusing to bind the defendant over for trial. Now, abuse of discretion means the decision falls outside the range of principled outcomes or when it misapplies the law. That's the Seawald case. People versus Seawald at SEEWALD, 499 Mich 111. It's a 2016 case. And the court has considered the entire record, which the court has reviewed the transcript. Also, the court has to consider that unless a proposed amendment would unfairly surprise or prejudice the defendant, an amendment to the information is permitted either before, during, or after the trial. Again, citing the rule I did earlier, Michigan Court Rule 6.112H. And a defendant may establish unfair surprise by articulating how additional time to prepare would have benefited the defense. That's cited in People versus Perry, 317 Mishat 589, a 2016 case. So what it comes down to is a prosecutor may amend a charge even where it results in a higher charge being brought, absent unfair surprise or prejudice. And that's in a recent Court of Appeals case, People versus Van S, VAN, capital ESS, all one word, 2024 case, but I don't have the site. So the people have sought criminal sexual conduct third degree, which was denied by the examining magistrate. The elements of criminal sexual conduct third degree include entry into a genital opening, which is being alleged here. According to the testimony, there was sexual intercourse, penile vaginal. And second element for CSC 3 would be that the defendant used force or coercion to commit the sexual act. Force or coercion means that the defendant either used physical force or did something to make the alleged victim reasonably afraid of present or future danger. The examining magistrate's position was that there was a gap in time from the time that they were at the door when it was allegedly asked that the alleged victim remove her clothing. And then they're upstairs engaging in intercourse. As a result, the magistrate determined not enough. Probable cause standard. Of course, that's what the examining magistrate has to consider. Now, when you look at, if you were to look at this case, just in that snapshot in time, there could be a basis to say, hey, look, there's a lack of probable cause because of the fact that we have, take your clothes off. No, I don't want to. upstairs, they engage in intercourse, then they leave. The testimony during the exam, though, alleges in part that during the course of the day, the alleged victim had been assaulted in some way, shape, or form, including alleged strangulation. And when you look at that particular day, that's what's being alleged. The complaining witness testified that they had been previously intimate. There's no question of that. That's her testimony. On the date of the alleged incident, she testified that the defendant asked her to take her clothes off. She said, I don't want to. And she did not want to because I just got hurt, assaulted. That was her testimony. I didn't feel comfortable taking my clothes off, and being asked what happened then, the complaining witness responded, I won't say forcefully happened, but he proceeded to tell me I should. Parties then had relations. When asked by the people then, which I cited a moment ago, was that with your consent? And the complaining witness stated no. Now, the record's not very clear relative to whether or not the no was stated to the defendant at the time. I have no idea. But according to the evidence presented at preliminary examination, which, by the way, is not a determination of guilt or innocence, it's probable cause. That's all it is. I always use the classic example, and maybe it's an old example, but it's one that I use. If you have an individual who is an alleged victim in a crime, and he or she testifies that the defendant did A, B, C, and D, and then, for whatever reason, the defense calls a witness at the preliminary exam, and I always use a hypothetical, so please bear with me. The Pope comes in and testifies, as an example. Pope comes in and testifies and said, no, the defendant was with me at the Vatican that day. Again, I'll manage example, but it serves a purpose. And at first blush, one would say, well, wait a second. One said it did happen, the other said it didn't. And I have the Pope telling me it didn't happen. Well, again, some people might say, well, if it's the Pope, it must not be true. It's not bound over. But that's not what a probable cause hearing is for. A probable cause hearing is whether or not probable cause that a crime's been committed and that the defendant committed the crime. And in that case, that is a classic question for the jury to decide, because it rests upon credibility, is what it does, because you have completely contradictory testimony from either side, stating one that it happened, the other said it did. Now, the district court, when it made its ruling, stated that the complaining witness did not adequately express her non-consent. That's the issue. That's the issue before the court. And under the Seawall case, you must consider the record as a whole, in that you must consider the entire record, period. What happened on this date? And allegedly, according to the witness, there was basically a day of getting together, alleged assaultive behavior, alleged strangulation, going throughout the day, from a motor vehicle traveling down the road to the defendant's mother's residence, allegedly continuing on. The alleged victim testified that she claimed she'd been probably hit 50 times, give or take. So if you look at it in isolation, I can understand the magistrate's ruling. However, when you consider the entire record under the Seawall analysis, the evidence this court finds at a bare minimum regarding the alleged assaultive behavior prior to any sexual contact demonstrates a reasonable inference of force or coercion. This is focusing on alleged gaps in testimony and the issue of expressing non-consent. That's an improper weighing of the evidence, and the court finds is clearly an abuse of discretion. It definitely falls outside the range of principled outcomes, because you have to look at the entire episode as to what happened on that particular day. And I'm not saying that the alleged victim's testimony is the gospel. It's only to consider probable cause. There's no contract.
It's not the gospel, but I will sing to you, Dwight, belatedly. Happy birthday to you. Happy birthday to you. Happy birthday, dear Dwight. Happy birthday to you. Yay! Happy belated birthday. Also, now I want to make like 10 pies. ADHD.
Contradictory evidence to it, other than what she's testifying to. If that's the only evidence the court has to consider, this court finds that when you look at it based upon the entire record, there's clearly an abuse of discretion. As a result, and regarding the CSC 1 portion at this point, the court does not find the CSC 1 component of it. I understand the people's argument, but what was asked for as well at the preliminary.
Thank you, Dwight, so much. The singing of angels. The singing music to my ears. Do. Happiest of birthdays, seriously. So glad that we are here to share with you. And thank you. Also, I've completely lost the plot with the case, but that's okay. We're just hanging out. This is what we do because we're friends, boo.
Examination was a CSC 3. And that's where the court's going. As I find that the district court abused its discretion in not binding over the defendant on CSC 3, court finds that the court's decision clearly falls outside the range of principled outcomes when considering the entire record, as the evidence clearly demonstrates at a minimum a reasonable inference of force or coercion, which is a question for the jury. As a result, the people's motion or the people's appeal, essentially, to reverse the decision of the district court to add CSC 3 is granted. Mr. Wallace, prepare an order to that effect.
Yes, Your Honor.
Also, the court has to consider any unfair surprise or prejudice. And obviously, this was brought up at the preliminary examination, which was held back on February 26th. So there has been notice, the motion is filed, trial is not until late August. There is court finds no unfair surprise or prejudice. Now, to be honest, from my perspective, sitting as a circuit judge, I think it'd be best advisable if you have the understanding that you may be asking for this, that it'd be best to ask for it or put the defendant on notice prior to the exam beginning. And Mr. Wallace, you don't need to
I
comment.
appreciate that, Your Honor. Thank you.
You don't, and I'm not pointing fingers or anything like that. All I'm saying is, at least that would put everyone on notice, look, this is what's happened. But under the circumstances here, again, it was provided before argument was made. No unfair surprise or prejudice. The motion is in the appeal, essentially. All of it granted.
Prepare the order, Your Honor, and I will also file an amended information adding that count.
Thank you. Now, back to, we have also a motion relative to change of venue as well. Tursky, you may proceed on that.
Thank you, Your Honor.
So, again, like I said before, an extremely unique situation here. This motion is filed just to make sure that we preserve the issue. I think it's going to be an ongoing problem. The people they do, bring up in their response, which is completely valid, that potentially, the court reserving determination on this until, we had an attempt to conduct one here. But I think the problem here is that Mr. Butterfield has been so highly publicized for other things. I mean, even just as of today, right? I mean, the YouTube channel that streams criminal court proceedings for Huron County Circuit Court has like close to 7,000 subscribers. I mean, there were 160 people watching this morning, and there were comments about Mr. Butterfield, and specifically, it's, and I understand the case that they're going to rely on, that yes, pretrial publicity alone does not automatically, require that we have a change of venue. However, it's not just publicity about the instance that he's charged with, rather, he's, being accused publicly all over different types of social media, within news outlets, YouTube, TikTok, Facebook, other platforms, of an unrelated investigation. His picture was posted all over, he could potentially be armed and dangerous, do not approach. I mean, there are thousands upon thousands upon thousands of Facebook posts and comments in regards to Mr. Butterfield. And I think that is, it's a huge concern. It's more than just a couple articles in the paper that, individuals may have been able to do it. I mean, I think that the potential jurors, in this case, I know that we are still ways away. I mean, by the time we get to that point, they're gonna have been repeatedly exposed to allegations, that, Mr. Butterfield may have, or may not have, completely committed a completely different, crime, that these allegations is far more serious, and I think that it is an issue. I think that it's a problem. I think that a change of venue would be warranted, because there are so many things being said about Mr. Butterfield online, and that it's going into this case specifically. When you're looking at that, I mean, it is a concern. I mean, when we're a smaller county, news travels fast. It's a very big concern, and I think that there will be a concern on whether or not we will be able to actually see a jury who doesn't already have a preconceived notion or opinion in regards to Mr. Butterfield. I mean, Mr. Butterfield has, even in attempting court, the last time we were here, he was yelled at, screamed at in the hallway as he is exiting. I mean, there are issues, Your Honor, I understand, and I'm not saying that, it's the people, I'm not saying it's the court. I mean, we have news outlets in the courtroom all the time. I understand that, I mean, reporting, it does happen, but it has begun it's become, it became more than that. We have individuals who, are, streaming things on, platforms, and I understand that there's a warning in regards to the YouTube channel. I mean, I'm not gonna lie, when I come here on Mondays, because my office is in Caro, I love to be able to watch, to see where we're at on the docket, so I know how much time I'm gonna have to make sure I can get here, because Cora's always very flexible with my schedule. I love that I have the ability to do that. I love that I have the ability to sometimes appear via Zoom. But I also know that individuals, especially individuals who are sensationalizing things and trying to create a platform, because there are a number of platforms in regards to a different investigation, and I'm not gonna go into that, I know the court knows what I'm talking about. It's a concern, because recordings are saved. Even with what happened here today, I have no reason to doubt that what had occurred earlier is more than likely already been saved, stored, and posted on other platforms. And I think that that's dangerous for Mr. Butterfield and his ability to have a fair trial. So I believe that a change of venue is warranted in this case. I do understand the people's position that, we are still here it's still early, and that maybe there would be the potential of being able to see an impartial jury, but I have very grave concerns for that. So again, we felt that it was absolutely necessary to place it on the record, and to preserve the issue, because I believe that this pretrial publicity, not only just for this case, but for a separate unrelated matter that Mr. Butterfield has not been charged with and is being accused of being connected with, is going to absolutely affect his due process rights, Your Honor.
Thank you. Mr. Wells.
Yes, sir. Council's right, we're asking the court to ultimately defer the decision until there's some proof that they can't get a fair jury. It's not time to base something on speculation, based on possible community posts or whatever else is out there. It's always interesting to me, and I've been doing this according to guests, I've been very clear here that I've been doing it for a while. And when I say that, I've been involved in a number of cases that have gotten publicity. But you get into the courtroom with a jury, what I think is a lot of publicity at something, many times they never even heard about it. Or even more importantly, you tell the court, I heard about it, But I can put that aside and judge this case based on the evidence before me at this point in time from the trial. I put everything else aside. And that's the question the court will ask, of course, of anyone in general, that's gonna be a juror. And that's when we decide, I would switch on and say we, that's when the court would decide if there's been publicity that is so prejudicial, so pervasive, that it's not possibly be a fair and impartial juror, because they say, no, I heard everything, I know everything, I can't be fair. We're not there yet. And so at this point, we'd ask the court to find, I'll say deny the motion, but we're not asking the court to deny the motion. We're asking the court to pause and wait until we actually try to get a jury, and then go from there.
Thank you.
Just quickly in rebuttal, I mean, and I understand that request, and I believe that it's reasonable, I get it, but the other question and the other issue that we have is one, we have an individual who's incarcerated, and so speedy trial is an important thing, obviously. Also, so are, the resources, the limited resources that we have, the court's availability, things of that nature. So we also run the danger of, okay, let's try it, but it very well may not be true. And so there is a concern about that. And I mean, I would obviously get into that later, but I need to bring it to the court's attention. We still believe that a change of venue, well, that early is still appropriate in this case, because I think there are a lot of additional things that, I mean, will need to be accomplished. It's a huge concern for me that we'll be able to even remotely come close to being able to impanel an impartial jury. And then the concern comes in with the extraordinary amount of individuals that we may have to impanel just to try to attempt to do that, the taxing amount of resources that it's going to take, as well as being able to properly investigate to make sure these individuals are not, I guess even being truthful, because a lot of times you do want to downplay those things. I think this pre-trial publicity has been, and this has been ongoing for a number of months. I mean, this isn't just Mr. Butterfield has been talked about for a week or two. Mr. Butterfield has been talked about 4 months, daily, consistently. I mean, there are dedicated pages and groups in regards to, you know, hating on Mr. Butterfield, and I think that that's going to, you know, become an issue within family and jury. So we would ask that you consider the motion and consider, you know, the change
6
that
months,
incorporated in this
Bruno.
legislation.
Thank you so much.
The
I know,
defense
Judge is gonna
filed
get
a
mad at
motion
me
to
now.
change the venue in this matter. And venue test is very simple upon good cause shown by either party under MCL 762.7. Now, generally, defendants must be tried in the county where the alleged crime was committed under MCL 600.8312. Unfair and prejudicial news comment of pending trials have become increasingly prevalent, and due process requires that the accused receive a trial by an impartial jury free from outside influence. That's cited as Samuel Shepard versus Maxwell, U.S. Supreme Court case 384 U.S. 333, back in 1966. The moving party has a burden of showing good cause for a change of venue under MCL 762.7, and the burden of establishing that prospective jurors have been influenced by pretrial publicity is on the party seeking that change of venue. And merely showing that jurors have been exposed to pretrial publicity is not in itself sufficient. That's citing the Florinci case, Florinchi, at 84 Mishat 128, 1978 case. Pretrial publicity, even pervasive adverse publicity, does not inevitably lead to an unfair trial. And you have to weigh it based upon how things proceed. Now, there's no question that at least the name of Jared Butterfield has been out in the public. Not going to deny that. However, this case, again, but maybe I'm under a rock, I don't know, live under a rock, but I don't recall specifically anything regarding pretrial publicity relative to this file. Be that as it may, it is the preferred practice of the trial court to defer ruling on a motion for change of venue until at least jury selection, and Ms. Risky has cited this, after jury selection has been attempted in the original county, namely Huron. That's People versus Harvey at 167 Mishap 734. It's a 1988 case. Now, regarding YouTube, this court, since COVID, has kept criminal proceedings publicly disseminated on YouTube. The reason the court has been doing so for these years, even past COVID, for the past maybe around 6 years, is simply transparency. All it is. It's not a matter of trying to get likes or dislikes. Frankly speaking, you don't get many likes in these types of proceedings. You don't get many, oh, the judge did this, the judge did that, oh, he excellent. No, we don't get that. We get rather the opposite. But that's understandable. That's what our society is all about. And people have the right to free speech, they have the right to comment. But the only reason the court does this is to provide the public simple transparency. This is how the court functions. This is how the court operates. This case is no different than any of the cases called on Monday or any of the cases 6 years prior. However, the court does not disseminate matters that involve HYTA status, 7411 status, because those are non-public, those are non-public filings that the court has to proceed on. That's the only way. Or if we have an individual testifying who is underage, we don't put the camera on that individual because, again, of privacy. And let's be honest, how about just common sense? The last thing we want to do is shame someone or have something on video that can be played years later. Now, mind you, these videos are deleted at the end of the day today. That's been the court's procedure for these past 6 years. The problem, though, the court has been seeing is that these videos have been recorded, as Ms. Risky stated, and have been played on other platforms within YouTube. And clearly, let me make it clear to everyone out there on YouTube, these are not to be recorded, period. They're not to be disseminated in any way, shape, or form. The reason for that is because, technically speaking, one could say, you have the right to freedom, you have the right to be in the courtroom and listen to it yourself. Come on in, you can watch it in person, live. Some people can't do that. That's why the court does as it does. However, when it comes to this issue today, relative to venue, maybe I'm going a bit off topic. The court will proceed, take the motion under advisement, and at the date of trial, we'll see how jury selection proceeds. If jury selection proceeds in a manner that we cannot select a fair and impartial jury, then maybe a change of venue would be appropriate. But we won't know that until the date of trial. And frankly speaking, in all my experience, and Mr. Wallace has me beat on the years of experience, but I can be honest, I can only remember one time of a change of venue when I was in private practice where a matter went from Tuscola County to Lapeer County. And it was involving a bank president. I mean, we're talking many years ago, but certainly it can happen. And it may happen in this case. We don't know, but we'll see as it comes along. So the motion is taken under advisement. Now, we have any other lingering issues other than the motion to disqualify or to strike? Anything
I
else?
saw the people have that.
Not at this time, Your Honor.
Okay, right, and we're not at motion cut off yet anyway. So the court's going to make a ruling relative to the motion to disqualify the prosecutor and the prosecution's motion to strike the witness list, which lists Mr. Rutkowski as a potential witness in this case. Now, the court has had the opportunity, as stated before, to read the transcript, read the motions, consider the arguments made by counsel in this case as well. And the court takes judicial notice of having experience both as an assistant prosecutor and as a defense attorney. I've had both over my course of years. And certainly as a defense attorney, no one calls a witness in a defense case, or defending a case, unless you know or have an idea what the witness is going to testify to. I mean, the old adage, you don't ask a question you don't know the answer to. Well, here's a classic example of it. You just don't call a witness willy-nilly and just say, okay, testify, what's going on, unless you have an idea what that witness is going to testify to. So on the defense side of it, clearly, that makes sense. But then I had the opportunity for approximately 6 years to be on the prosecutorial end of it as well. And certainly, law enforcement has its duty to investigate crimes, provide police reports to to counsel. And so counsel has a better understanding of what in the world they're dealing with. Not only the defense, but the prosecution as well. That's the course of business. And here, what we have is the court understands it. And again, I'm not privy to police reports. And if anyone thinks that the court has a copy of a police report regarding any incident, is completely untrue. When a jury gets selected for a jury trial, the only facts I know of would be contained within the file, in the pleadings, but no police reports, no factual information, no witness statements, nothing. Now, there's a preliminary exam transcript maybe, but that's the extent of it. That's all there is. And so when it comes to a jury trial, the court, just like the jury, really hears the evidence for the first time. That's the perfect world. Now, obviously, we have to be screened from reading maybe some Facebook posts or any social media type stuff. Press reports are press reports, but they're only reporting on information that is provided to them either through court proceedings or through witnesses or statements provided by attorneys, witness, whatever the case may be. But actually, the court actually stays away from that as well. And I've said this before in years, well, even today, any case that the court presides over, the court purposely doesn't even read if habitual offender status is sought by the people. And the reason the court does that, the court doesn't want to have a preconceived notion, oh, well, this person had a prior conviction for this, prior conviction for that, they must be responsible. No, we don't do that either. Here, though, on the prosecutorial end of it, as the court understands it, approximately a week prior to the preliminary examination, the prosecuting attorney, the elected official of this county, prosecuting attorney Timothy J. Rakowski, met with the alleged victim in this case. It was apparently brought out to the prosecutor that an alleged criminal sexual conduct had occurred. That's all I know. I don't know anything else. I'm guessing that information was, well, I'm not even gonna guess. However, there were questions brought during the preliminary examination, which the court has already referenced, regarding anything else happened. And then there was testimony regarding an alleged criminal sexual conduct matter. The defense position is, well, it was disseminated to the prosecutor. He should be a witness to this case. And again, it appears from the argument of Ms. Risky that there's nothing contained within the police report regarding any alleged criminal sexual conduct. That's how I understand it. I don't know, but there was nothing here. Definitely, Ms. Risky did not argue before the court saying that there was alleged criminal sexual conduct in the initial police report.
Just for clarification, the court, that's absolutely true. At the time of the exam, there was nothing in any police report. She's since then received a police report, but that was after the court. But at the time of the exam, people would agree there was nothing in the reports that would indicate that.
So, at first blush, being on the defense side as well, where did that come from? That doesn't make much sense. Why would that come out all of a sudden? Well, it came out according to the information provided to Mr. Rakowski from the alleged victim. As a result of that, the examining magistrate wisely decided, before even a bind over, to have further discovery on the issue. A subsequent police report was generated, which would presume, this court would presume, would indicate that the alleged victim was questioned regarding an alleged criminal sexual conduct. Police report was generated and provided to defense counsel. Then a decision was made at the district court level. And here, because it appears that it came out first to the prosecutor, that individual could be a potential witness. And the same rules apply to defense attorneys as well as prosecution regarding discovery, etc. But when you interview a witness from the defense side, I mean, unless, well, not even that, when you do your investigation, because you have to do your due diligence as an attorney, to make sure you know what the information is. You question your witness as you proceed on. The same applies to a prosecuting attorney as well. I couldn't imagine all of a sudden the police report indicates that the victim claims A, B, C, and D. You don't talk to the witness. You merely put that witness on the witness stand. The witness testifies, and then something comes out that you had no idea about. That's not the real world. Prosecutors are allowed to interview and meet with witnesses, just as defense would be. And if there are any notes taken, anything like that, same as defense, that's work product. That's not discoverable either. And the idea here is, again, because this came out for the first time, the motion being brought. And the court looked at the case law pertaining to, well, is that testimony available from another witness? Well, clearly it is, from the alleged victim. That's it, from the alleged victim. Because if the court accepts the information contained within the exam transcript, there are only two people involved. So it's clearly available from the alleged victim. It's not exclusive to the prosecuting attorney. Clearly the evidence is material. There's no question that it's material, but all the court knows is that there was no alleged CSC. And this court finds that there's no discovery violation. The court finds that there is nothing in the record. Now, if the witness said something completely different or added material facts to the prosecutor that may be different from contained within the police report, and the court knew that, maybe that's something different, but that's not here. All we have is it was reported to the prosecutor. When you look at the case law and you apply it to the case here, that the testimony primarily, not exclusively, is available to another witness, not exclusive to the prosecutor. The motion to disqualify the prosecutor is respectfully denied. And I agree with Mr. Wallace's position on this issue as well, because if we were to do that in this case, we'd have to do it in every single case. As a result, the motion, as I stated, to add or to disqualify him is respectfully denied. The motion to strike, however, is granted. Present orders to that effect as well.
Yes, sir.
Anything else we need to address for the record this morning, Council?
And that's for the people.
I'm just gonna make this comment, Your Honor. I know that the court's already made their ruling. That is our issue. The issue is that we do not believe that we're ever gonna know what it is she specifically told Mr. Rakowski, because we're never going to be able to ask him. And I understand that that's also obviously a question for the court. So I'm just putting it on the record, preserving the record.
No, and I appreciate that as well. We all want to preserve the record to make sure that if this is reviewed by anyone, that it's done so, the record being absolutely clear.
Yes.
But the same applies though from the defense standpoint, because if you were to flip the coin, the defense attorney would be potentially disqualified and have to testify. Secondarily to that, there was also a jury instruction which the court failed to mention. It's one of Mr. Wallace's favorites, by the way, because it's been asked for in a number of jury trials that the court has presided over the course of years. That is talking to an attorney. There's nothing wrong with that. That's basically what the jury instruction is. So the objection is noted for the record, and that'll be it. Thank you.
Oh my God, it's finally over. We did it together. Thank you so much for being here. Now listen, the judge is not going to get mad at me because the judge understands something. We are all about transparency as well. We actually would crowdfund to get him a new sound system. I bet that we could do that. We would make that happen. If he reached out to me and he says, Paisley, well, how could you, Paisley? I would say, Judge, can we get your audio fixed? Also, we are very transparent around here, but I don't, as CYP pointed out earlier, I have a personal philosophy on my channel, which I'm in charge of, that I don't name people's names. So it's not like anybody can search up Mr. Butterworth or Butterfinger or whatever his name was. We don't do that around here. Vicky, we're sending you good vibes in Beverly too. My two ladies, please be good. Please be safe. Everybody be happy. Thank you all for being here. If I make a lemon meringue pie, I'll take a picture of it. Seriously, guys, appreciate each and every one of you, all of your generosity, all of your time. That is very valuable, and I so appreciate you hanging out with me. Do me a favor. Remember that I love you, and I'm proud of you. And I will see you in the next video. Okay, bye.
Ways down and ready to ride.